Hey guys, welcome back. What I want to go over now is the Milestone One assignment for this week so that you'll have a good idea as to what's expected, and then hopefully maybe I can fill in some blanks for you regarding parts of the assignment. So the first part of the assignment is having you look at what is required for different practitioners in the criminal justice system to be able to conduct a legal search. And then to give an example of interagency collaboration when conducting a legal search. And so what I'm going to do first is just go over what's required for a police officer, probation and parole, and then a correctional officer. And then based on that information, you can use your creativity to give me an example as to this interagency collaboration and how it might apply when conducting a legal search. Okay, so in order for a police officer to conduct a search, a police officer is going to need probable cause. That's the key legal standard for police, probable cause, in order to conduct a search. They can also get consent, and that's a way to conduct a legal search, or there might be some type of exigent circumstance or emergency circumstances which require the police officer to act immediately. So for example, maybe somebody calls in and says the neighbors are arguing and the officers get to the front door and they hear a struggle and somebody screaming for help. If the officers were to open the door and run in, that would be considered legal, and then obviously anything that they were able to see as they were inside this room legally could be seized as evidence. But the point being here is that police officers have a pretty high standard. That's probable cause. And that's what's needed to get a search warrant, and that's what's needed for a police officer to conduct a legal search. So the focus here should be on probable cause, which is, again, which is a pretty significant standard, and it's the highest standard of the three that we'll be speaking about today. Now, one of the things I do want to talk to you about is, let me see if I can move my slide down here. There we go. Remember, you can also submit this assignment by using a PowerPoint presentation other than a paper. So I just want to point out that if you do elect to do that, PowerPoints have the ability for you to add notes. So down here in the bottom, you can see I've just made a brief note. It says here you can include additional notes and references to support your position, or our textbook is always a great resource. It contains other sources as well. In other words, you can add, even though you might say that, in order for a police officer to conduct a legal search, you have to have probable cause, consider exigent circumstances. You can also then include some notes down here to add to this. Maybe, like I said, giving you a specific example or using your textbook as a reference. So that's how, if you elect to do this this assignment as a PowerPoint presentation, you can add more information. And so basically, you're just going to go up to whether you're using a Mac computer or whether you're using Microsoft, and then you can go up and click on Add Notes, and then it allows you to add notes. And then when I get your assignment in a PowerPoint format, then I can look for those notes. Okay, so I just want to make sure we talked about that before I lost focus here. So hold on, let me get this, let me get my slide back in queue here. I'm going to slide it back down. There we go. Okay, so that's for a police officer. So again, a police officer has to have probable cause. Probation officer, this is a quote taken from the textbook, but basically it's from former Chief Justice Antonio Scalia, and he stated, "It's always true probationers, as we have said, true parolees, that they do not enjoy the absolute liberty to which every citizen is entitled, but only conditional liberty, properly dependent on observation of special restrictions." Meaning that if you're on probation or parole, you do not have absolute immunity from searches, okay? Because basically, if you're on probation or parole, the courts have said, instead of sending you to jail or prison or keeping you in prison. We're going to release you back to society, but you're still going to have search restrictions. So typically what happens before somebody elects to go on probation or on parole, they're given terms and conditions of probation and parole, and oftentimes you will find search conditions. In other words, that a probation officer can search your residence at any time, generally based on no probable causes needed, because random searches, as is done in corrections, is a tool to prevent those on probation or parole from being involved in criminal activity. The fear that maybe my probation officer, parole officer is going to come by and want to search my house, search my car, search me, acts as a deterrent. But the other fact is you're still under control of the state, but you're not in jail. You're on probation or parole. Okay, so again, probation officers really don't need much. The search is going to be limited to that of their probationer. So a probation officer cannot search somebody who's not on probation unless, again, they would have to have probable cause or some other set of circumstances. Search terms are often included as part of probation, and the probationer has to agree to those conditions before being placed on probation. If he doesn't agree, then he can go to jail. And that's a simple way to put it. No probable cause is needed, and this is generally outlined under the conditions of probation. Now, oftentimes the issue is whether or not a police officer can search somebody who's on probation. I'm not going to get into that really too much because sometimes that depends on the state, that depends on the conditions of probation or parole. But generally, a police officer will be in communication with a probation or parole agent if they run across somebody that's on probation or parole, and then if they can maybe outline to the probation officer, parole agent, what this guy's up to, maybe he's involved in some criminal activity, then the probation or parole officer can give the police officer authority to search the vehicle. But we're going to just focus on probation officer here. So again, it's going to be limited. They don't have to have any probable cause, but it's also going to be limited to, the probationer himself. So his car, his person, his room, his residence, things like that. If a guy on probation, for example, is visiting a friend, the scope of the search is going to be limited because the friend's not on probation, the probationer is. Okay, but I don't want to get too much into it, but this is just the nuts and bolts of it. So again, probation officer has a bit of latitude when it comes to searches, more so than a police officer, but it's going to be limited to those under his care. Correctional officer can conduct legal searches within the penal institution. Again, no probable cause or search warrant is necessary. There's a case you can look at. It's called Hudson v. Palmer. Obviously, institution safety is paramount. So oftentimes you'll see or hear about correctional officers just conducting random searches of different cells. And it's designed to keep inmates on their toes, keep them honest, because they never know when they're going to be subject to search. Over the years, there have been some issues arising over cavity searches, but generally, as long as there is some general penological interest or need to conduct some searches, the courts have said those searches are okay. But correctional officers have quite a bit of latitude in conducting searches, especially within the institution, even to the extent of people coming to visit can be subject to search. And if you don't want to be searched, then you are shown the door and you can leave and not do your visit. So again, it's going to be focused to the penal institution itself, and outside the penal institution, they really have no authority to conduct any searches because inmates are always housed within the prison. All right, so that's how correctional officers operate. Got a lot of latitude in terms of how they conduct searches within the institution to maintain a system of security within the prison. Next, we're going to talk about police officer collaboration, and this is where I'm a police officer, a police detective, and I want to find out about somebody who's on parole or somebody who's in an institution, who they've been talking to on the phone and who they've been visiting, and basically who would I need to contact. Generally, it'd be somebody from the prison administration, somebody from the warden's office. Usually most institutions have a liaison with law enforcement. So there's somebody within the institution that acts as a liaison with police to share this type of information. So if I wanted to get information on an inmate, find out who he came to visit, who visited this inmate, who he'd been talking on the phone, then I would contact somebody from the institution, okay, generally from the warden's office at some level of administration. And again, they don't have to have any probable cause, any search warrant to search if it's done for administrative purposes, inmate security, institutional security, things like that. So that's that level of collaboration that can take place within between law enforcement and, in this case, a prison. So the police officer will be contacting somebody from the warden's office, and again, usually prison administration, and oftentimes there is a liaison. Pre-sentence investigation ties into number C, and basically who does a pre-sentence investigation after somebody's been convicted of a felony, and then the judge has to determine the appropriate sentence. And you can check our textbook, page 199, page 200 will give you a good answer to that question. But basically we're talking about a probation officer. So a probation officer is the one that does a pre-sentence investigation report. And basically what they're looking at is a deep history of the offender's life, his growing up, previous crimes and punishments, his attitude, has he had any jobs, family ties, things such as that. So it's a pretty in-depth report that's done by the probation officer to assist the judge in determining the appropriate sentence. And oftentimes the probation officer will go ahead and make a recommendation to the court in punishment. And I would say my experience has been that overall the judges tend to follow the probation officer's recommendation when it comes to punishment. But it is going to be the probation officer who does the pre-sentence investigation report. That's the most common answer throughout the country. So you can see here what the report will include: defendant's employment history, family relationships, personal history, other factors, again, convictions, seriousness of the crime. Federal courts use federal probation officers or parole officers to prepare these reports. Again, they're very in-depth, so if you're interested in a career with probation or parole, please note that you got to have sharp writing skills in order to assist the court in making a clear decision on what the punishment should be. And then I'm just going to move along here. So pre-sentence investigation report is going to contain recommendations for specific criminal sanctions, including whether it's prison time, jail time, community service, or any type of other sanctions. Okay? So that's that in terms of who does a pre-sentence investigation report. The last thing you have to do is select a case, and then you have to describe the impact that this case might have on the criminal justice practitioner. These are all dealing with corrections, by the way. So these are all cases out of corrections. The first two cases are United States Supreme Court cases, and you can tell that by U.S. United States Supreme Court. The third one is from California. It's a California Appellate Court of Appeals case. I would tell you the Rosencrantz case it's challenging. So I would steer you towards the Turner v. Safely or Estelle versus Gamble if you like to do so. I think these are the easier of the two. Rosencrantz raised a lot of legal issues that might cause some confusion. So focus on these two and then address the critical prompt, okay? So I'm not going to go into detail about the cases. You can go ahead and read those, but just know that I think the first two are your safest bet. Again, Rosencrantz, and I misspelled it there, is a little bit of a complicated case because I've read it before and it's a bit complicated. So I'm going to just move this up real quick. So this is a source for you guys that I wanted to share with you. It's the Supreme Court link, and there it is right there, www.oyez.org. Oyez. It's a great source for Supreme Court decisions because it includes the actual audio argument. So like I said, if you're busy having lunch, you can listen to the audio arguments and then you'll have the gist of what's going on. There's also a very short synopsis of the facts of the case that might help you greatly as you work on this assignment. Okay, so take a look at that. That's a great resource, and you might just keep it in your computer for any other classes you have. All right? So that's it for this week. Other than that, the last thing you have to do is, based on your findings regarding the differences in how each branch communicate with each other, which career path is most in line with your communication and collaboration practices and why. So make sure you don't forget to address that and tell me which career path you think suits you best. All right, that's it, guys. Thanks, and let's have a great module week. Bye.